Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hey everybody, how you doing? Doing a little video today to talk about something that I was discussing with my friend Tracy in Brendan's group the other day, and I think it's pretty interesting stuff. She had posted a link to an article that I went in and started reading it, and it started talking about the Wisconsin Supreme Court and its decision in Jarrell versus the state of Wisconsin. And it's quite interesting because it's that particular case, that where the Supreme Court, in its judgment, called for the electronic recording of juvenile interrogations. So that's that landmark moment where that happened. That's why Brendan's was recorded. It was among one of the first ones, right? So that makes Brendan's case somewhat unique, right? Especially since, as you're going to see with these two cases, Jarrell and Brendan's, there is a lot of similarities. A lot. Okay? There's a couple little things that aren't quite the same, but I think when we factor in some things about Brendan, I think the scales even out. But I'll go through that here in a minute. But the thing is that in this judgment, they found that what happened to Jarrell was just so unacceptable, and that they basically started to they asked for, in their decision, electronic monitoring of juvenile interrogations. So why then, when a case like Brendan's comes up to the Supreme Court, it's recorded because, for the very reason that they were concerned, because they were concerned about being able to see what was happening in these interrogations, because they obviously, going along with the Supreme Court and its special care, it makes sense, right? It makes sense. The Supreme Court has asked for special care when it comes to juveniles, and so it only makes sense to record the interrogations and interviews so that people can look at it with their own eyes and make their own judgment as to whether or not that kid's will was overborne, or whether he was threatened or intimidated or whatever. All that stuff that you can't deny when you just see it on tape. That people can come into court and fudge the facts. No, when it's right there on tape, then these judges have the ability to look at the situation and go, yes, I think his will was overborne. No, I don't think his will was overborne, basically. But coming to my point, what's interesting to me is the fact that the Supreme Court of Wisconsin just flat out denied Brendan's case completely. They didn't even say why they didn't hear it. They didn't even bother to say why. Now, that's just how little interest that the Wisconsin Supreme Court showed in a case that was very similar to Jarrell, the case that started the whole electronic, recording of juvenile interrogations and interviews, right? And yet they just completely casually just brush Brendan's case aside. So it seems odd, right? It's just something that that her and I were talking about and just going, yeah, it's just very, very strange that, and when we get into what's, the similarities, the thing is that, okay, Jarrell was 14 years old, right? But Jarrell, I think, was a pretty street smart kid, okay? Because all throughout his interrogation, he was asking for his mom and dad. He was asking to call them. He was repeatedly asking to call them. The detective kept saying no, and he understood that he was in trouble. He understood that he was in a situation that he was not equipped to deal with, and he was asking for a parent, right? So that's where this case is a little bit different. Where this case and Brendan's are a little bit different, but it shows that this kid, for a 14-year-old, was pretty quick to pick up the fact that he knew he was in deep doo-doo. And he wanted his mom and dad there, and he repeatedly asked for his mom and dad there. And I think that it's pretty clear that Brendan did not think that way. Brendan did not at all think that way. He didn't. He just sat there and was just docile and kind of allowed what happened to happen. So I think that's where it kind of puts Brendan as a 16-year-old and Jarrell as a 14-year-old somewhere near a level playing field, really, in my opinion. Now, the Wisconsin Supreme Court, in its evaluating of Jarrell and the fact finding and stuff like this, found that at the time of his interrogation he actually had a 3.5 GPA, but his IQ test and his school performance previous to that was not so great. His IQ was 84, which is basically low average range, and so they determined that he wasn't like the brightest. But I disagree. I think he was a street smart kid. Because, like I said, I think he picked up on the fact that he was in trouble quick, and he was asking for his mom and his dad. And it's one of the things that factored into this decision for these judges as well. The fact that he kept asking for his mom and dad and was denied repeatedly, and it was eventually basically forced. Basically a written up confession that was written by one of the detectives was put in front of him, and he basically signed it, because after a long day, he just signed the thing they put in front of him, because he was just, I guess, that's how it is, right? I mean, and he's just a 14-year-old kid, right? He'd been there all freaking day long. They picked him up at his house at 9 in the morning and left him handcuffed to a wall for 2 hours when he first got there to the police station. And I mean, they just put this kid through, the ringer. And eventually, in the end, he just signed the piece of paper they shoved in front of him. So that was the thing here with Jarrell. He was clearly a little bit more savvy, I would say, than Brendan was, and he was obviously a little bit more willing to defy the officers and fight for his innocence, and not just give in to their will. So I just think that's important as we go through some of the things I'm going to show you. So what I want to show you right now, first thing, is number one, we're going to see that good old Peggy L was AG at the time when this was in the Wisconsin Supreme Court. And we also see here that we got an amicus brief in this Wisconsin Supreme Court case from Mr. Stephen Drizzen and Northwestern's Center for Wrongful Convictions of Youth. Yep, amicus brief in there. So I'm going to show you that real quick, and then we'll come on back. Supreme Court of Wisconsin, in the interests of Jarrell C.J., a person under the age of 17, State of Wisconsin, petitioner respondent V. Jarrell C.J., respondent appellant petitioner. For the respondent appellant petitioner, there were briefs and oral argument by Eileen A. Hirsch, Assistant State Public Defender. For the petitioner respondent, the cause was argued by Gregory M. Weber, Assistant Attorney General, with whom on brief was Peggy A. Lautenschlager, Attorney General. An amicus curiae brief was filed by Stephen Drizzen, Chicago, Illinois, on behalf of the Children and Family Center of Justice of Northwestern University School of Law. So that's our involved characters there, some recognizable names there for sure. This next clip from the opinion is going to deal with what I was talking about, of why I think Jarrell and Brendan are kind of more on a little bit more of a level playing field than just the actual chronological number of their ages when these things happen to them. So we'll go ahead and move into that right now. We agree with the case law's recognition that youth is more than a chronological fact. Eddings versus Oklahoma. While not necessarily dispositive, Youth remains a critical factor for our consideration, and the younger the child, the more carefully we will scrutinize police questioning tactics to determine if excessive coercion or intimidation or simple immaturity would not affect an adult has tainted a juvenile's confession. So now that's interesting right there, folks. That's kind of why I wanted to show this. It's talking about scrutinizing police questioning. Well, look at Brendan. He has been clearly established as more suggestible than 95% of the population. Does that not count for anything? I mean, that as a 16-year-old who's that suggestible, doesn't that mean something? So I just like that particular bit of that opinion because it's really the Wisconsin Supreme Court acknowledging the fact that age, the number itself, doesn't necessarily mean, I mean, it's a subjective type of thing. Not all 14-year-olds are the same. There are some 14-year-olds who are more advanced and do like things that tend to be done by 16-year-olds and that sort of thing. I mean, there's different levels of development. So the number assigned to age, I mean, here they are acknowledging that the number assigned to age is kind of just it's like a road sign. And I just think that very much applies to Brendan's case as well, because Brendan, yes, as a 16-year-old, his age, the number was higher, as a 16-year-old. But the thing is when you take into account Brendan's level of suggestibility, where he is more, at the time of the interrogations, more suggestible than 95% of the population. I mean, you gotta sit there and think about that for a second. 95% of the population. That's really a lot. I mean, so you gotta take that into account. I think it's a significant factor, and I think it kind of brings Brendan as a 16-year-old and Jarrell as a 14-year-old pretty close together in that sense. Especially because I feel Jarrell was a pretty savvy, street smart kid. And I think Jarrell's problem wasn't that he wasn't smart. I think Jarrell's problem is that he didn't really apply himself in school, because for some reason at the time of this when he was interrogated, he was getting a 3.5 GPA. He had applied himself. And when he applied himself, obviously, he was capable of getting a 3.5. So this is what I'm saying about Jarrell. Jarrell was a pretty street smart, pretty savvy kid who understood things, but maybe didn't want to always do his homework. Right? So, okay. That's what I kind of think. So, when you take into all these accounts, now, there's other things about this. Now, there's one thing that the cop was doing. The cop raised his voice at Jarrell a few times. He claims it wasn't yelling. He said it was short of yelling, but he raised the tone of his voice because he was trying to make a specific point. Well, that raising of the voice is one of the things that also mattered in this confession. So, I mean, but that goes with the kind of classic cookie cutter confession that these courts are used to seeing and granting. The thing is like, if you remember what Judge Rovner was saying in her dissent in the Seventh Circuit's en banc decision, in her dissent of that decision, she was explaining the fact that the courts and her colleagues all need to come into the 21st century and need to acknowledge the fact that people are out there falsely confessing a lot more than previously thought. DNA is proving this. Social experiments and studies are proving this. And she was basically beseeching her colleagues, all of them, all over the country, to begin to understand the tactics of psychological coercion and more subtler forms of coercion than the kind of mainly accepted version where a person is threatened or made promises, or that sort of thing, where it needs to be accepted that there are other psychological tactics used that do cause people to confess, and that's what Judge Robner was pointing out, and it is true, and it is something that needs to be addressed, in my opinion. So we're going to move on to the next bit now. Yes, now we get to where they talk about experience with law enforcement. Oh yes, here we go. In this case, Jarrell's experience with law enforcement was more limited and may have contributed to his willingness to confess in the case at hand. Jarrell had been arrested twice for misdemeanor offenses prior to his interrogation for armed robbery. In both instances, he answered police questions, admitted to involvement, and was allowed to go home. Significantly, he was never adjudged delinquent. We note the argument of Jarrell's counsel that such an experience may have taught him a dangerous lesson, that admitting involvement in an offense will result in the return home without any significant consequences. And so, I mean, I would argue that that's pretty much the same exact thing that happened to Brendan. Okay, so follow with me here for a second, people. They're saying that Jarrell had 2 previous run-ins with law enforcement, right? Okay, 2 misdemeanor things, whatever, they were minor or something, probably stealing candy or something, right? Something stupid and silly. He was, questioned by the police. He basically willingly answered their questions. He admitted his fault, and he was allowed to go home. With no significant consequences, and he was not labeled or reported as a delinquent. Okay, he was just allowed to go on his merry way. Okay, so then they're saying that because of that, it may have given him, as a youth, as a youngster, it may have given him the improper impression that admitting fault means you get to go home without significant consequences. Well, I would argue, number one, Brendan had no significant run-ins with law enforcement for any reason at all, okay, until the Stephen Avery case. Okay, then we start on November 6th, the day after the DRAV-4 is found. They are on Brendan like, white on rice, okay? They are all over him, and he resists them. He resists them all throughout. That interrogation in the sheriff's vehicle, the Marinette officer O'Neill. So that's number one. But in that interview, I say interview, but anyways, in that interview, they actually give Brennan a full-on specific promise. They tell him, you need to stop worrying about getting in trouble. You need to stop worrying about going to jail, because that ain't gonna happen. That is a specific promise. Now, the courts and all that or whatever are saying that it doesn't matter. It doesn't matter. Well, Wisconsin Supreme Court just showed me that they went and looked at Jarrell's past with law enforcement. So why doesn't Brendan's past with law enforcement matter? Okay, because there's November 6th where he was given a promise that he was not going to be going to jail and anything. He needed to stop worrying about that. Now, obviously, he was left alone for a long time until February 27th when they interrogated him again. Okay, it was on a Friday, and they got him to say something, whatever, and they let him go. And then they had him and his whole family come over to the Fox Hills Resort. If you remember, him and Barb and the boys, all of the Dassey boys went over there. And we don't even know really what happened at Fox Hills because there's no real records of it. But apparently there was something that happened, and there was some, I guess, maybe an altercation or a potential altercation almost happened between Fassbender and I think one of the Dassey boys, but we have no idea what any interviews happened there, anything like that. We don't know. It was just that was at Fox Hills. So Brendan has this experience of the law enforcement coming and asking him questions, and he tells them what they want to hear, and he goes home, or he whatever. Nothing bad happens to him. He's getting that reinforcement that whole entire weekend leading up to March 1st. And then on March 1st, they put the real press on him, and he basically confesses to everything he thinks they want to hear. And that is obvious. And that is really super obvious here. And so I would argue that Brendan's previous in contact with law enforcement over the weekend before March 1st showed him the same exact thing that they were suggesting that Jarrell learned from his first 2 experiences from law enforcement. So that's why I added that. So like I was saying, there's a lot of things about Brendan and Jarrell's case that are very, very similar. There's a few things that are different, but in my opinion, they have a lot of similarities, a lot of like common threads that running through them. And it's just strange to me that after the Supreme Court deemed Jarrell's case was concerning enough that they wanted to institute electronic recording of juvenile, interrogations and stuff and confessions, then why didn't they take an interest in a case like Brendan's when it came up as one of the very first interrogations that was recorded? I just can't understand why they cast a blind eye to Brendan's case when they petitioned the Wisconsin Supreme Court. It seems a little bit incongruous to me. I just, I see the way that they went with Jarrell, and I see how similar it is to Brendan's case, and yet they completely shined Brendan's case. They didn't even give a reason why they wouldn't hear it. They just completely ignored it. So, I don't know, maybe some of them, maybe somebody there reviewed it or whatever, but I'm just basically saying they didn't offer any statement as to why they weren't going to hear it or anything. They just didn't hear it. So that's what we were talking about, how odd that seems, So that's about it for this one, folks. I just wanted to talk about how it's odd, really, that the Wisconsin Supreme Court just kind of passed over Brendan. And that's about it. If you haven't already, please hit subscribe. We'll see ya.